Hello, I am Jorge Goldstein. I am a partner at Sterne Kessler, Goldstein Fox, an IP firm in Washington, D.C. I am the chair of the biotech and pharmaceutical practice in the firm, and I recently founded and have been developing a pro bono practice in the firm that deals with the interaction between intellectual property and human rights. Traditionally, it has been hard for patent lawyers to find an area of pro bono that would fit well with their training in intellectual property. So patent firms have usually done pro bono work in things like representing the homeless, the poor, battered women, veterans in veterans' appeals, and so on. But it occurred to me that there would be a better fit between certain areas of human rights law and intellectual property that might be of more interest to patent attorneys and intellectual property attorneys. And those deal with the interaction between what we call economic, social, and cultural rights as a subgroup of human rights and intellectual property. These things deal with issues like the right of indigenous populations to their cultural know-how, to their medicinal plants, to their music, to their folklore. And so we have established this practice, which I think is a pioneering practice, and it is one of a kind, in the interface between economic, social, cultural rights and intellectual property. We have a number of cases already. We have one very interesting case that deals with the protection of certain intellectual property that is derived from a fruit that has been used in the rainforest of a South American country. And through the protection of this intellectual property, we are presently negotiating international licenses with multinational companies who might be interested in placing extracts of this fruit into things like food, cosmetics, pharmaceuticals, and so on. The relationship between access to rainforest, indigenous rights, and intellectual property is controlled by the Convention of Biological Diversity, by the Nagoya Protocol on sharing benefits and access to the rainforest, and we work in that general legal context in addition to the traditional intellectual property. Another case we have deals with a concern that a government agency has also in South America, that certain fruits or roots that have been known to their indigenous populations were used to extract certain materials that were then patented in the developed world, and we are seeking ways maybe to challenge those patents. We have several other cases that are coming our way in this general area. It's a very exciting area, and if you're interested in either working on this type of pro bono practice or in sending us a case, please be in touch with me. Thank you.